So when does a contracting dispute become a criminal case? So since the early 2020s, the legislature has expanded upon what we consider the home improvement fraud statute, which turns what you would think would be a civil case, suing a former contractor to get your money back. Maybe you didn't like how the project was done, where now it can potentially be a criminal case graded the same as theft, right?
Yes, I mean, as a criminal defense attorney, I think it should just be dealt with civilly. Unfortunately, there is a criminal code as well. And yes, it can be dealt with and should be dealt with civilly, I think. But unfortunately, we see it often become a criminal case as well. And the requirements for it to become criminal is that a substantial portion of the work was not completed, that it's been 90 days or more since the start of the project, and that there has been written notice after those 90 days requesting a refund, and after that refund was not provided within the 10 days, it's rejected after sending it by certified mail or by hand delivering that request for a refund. They refuse to give you that refund. Then you can send that to the Attorney General's office with the Consumer Protection Agency portion of the Attorney General's office, and go to the DA's office and ask for criminal charges to be dealt against that contractor. And it's not just home improvements, although it's technically called the home improvement statute. It's also for new home projects, right? So you hire someone to either build a home for you or a portion of your house through the home improvement aspect. Then you could potentially bring criminal charges. And there's many potential defenses to this. The most common one that we see that's actually being litigated right now in the appellate courts is, what is the definition of substantial, right? There is no definition. Is substantial 15%? Is it 30%? Is it 51%? The courts have not actually come out and said what a substantial portion is. And does substantial change when we look at the degree of the contract, right? So if we're talking about a $5,000 job, as far as getting concrete pavers in the backyard, is substantial portion $1,000 out of that 5,000, 20%? Maybe not. But if we're looking at $1 million home, a $200,000 portion of the job, 20%, is a lot more significant, and it may be substantial. And because there are no deadline or no actual guidelines for the courts to determine whether that small project or big project and the percent of work completed creates that substantial portion of the job, makes it very hard for the courts to decide, is it criminal? Can it be a substantial portion? It's potentially a jury issue for the jury to decide, but criminal defense attorneys have litigated this. We have litigated this, and it is currently, like I said, on appeal as far as there needs to be a definition. Because if there's no definition, it is unconstitutionally vague. Because as a contractor, how am I supposed to know whether I am potentially criminally liable for something versus civilly if there is no definition? That is the issue with the law as far as the home improvement fraud statute. There's also other defenses as well, right? Yeah. So let's talk about the other defenses.
Yeah, so first thing we're looking for, like any kind of theft case, was there any intent? Right. Simply having a customer who is not happy with the job does not mean that you intended to defraud them.
Yeah.
Right. It's if in a case involving that's much more akin to being handled in a civil court rather than handling in a criminal court, even if it meets the civil definition.
Unfortunately, too often, prosecutors, victims, they try to just say, well, he wouldn't have done it if he didn't have the intent. But as defense attorneys, are there ways that we can prove that our clients didn't have the intent? I mean, what are some piece of evidence that we might look for?
So any proof that you have from the job, building receipts, supply receipts, photos of the job being done over time, right? For an example, and you talked about how it doesn't just have to be on a house, right? If you've been contracted to build somebody a dock, and you've cleared out the land where it's going to be laid, and you've bought all the lumber for putting down the dock, and you've bought the stuff to retain it, right? That's one that can both be a substantial step, and that can show that you never had the intent to defraud these people. You've been purchasing the required stuff. You've been taking steps as far as performing the labor, right?
Yeah.
It looks like you intended to do that job, not that you intended to defraud them.
Exactly. Text messages. So we're looking at text messages with the potential victims. Also, any text messages that we can show with, workers. So if you're a general contractor and you hire a sub, any text message with the subs, any conversations you've had with the subs, subcontractors, or their employees, those are all witnesses that could testify on your behalf as far as the conversations you had with them and what you intended to do on this project. And if they can show maybe a substantial portion of the work was not completed yet, and you just have a disgruntled, alleged victim, customer. But if you didn't have that intent to defraud, like Andrew said, it's not a crime.
Well, let's with an example though, because we talked about the 90 days since the start of the project. What if it rained for 90 straight days?
Yeah.
All right. Did you intend to defraud them at that point?
Right. Exactly. That's why there's so many factors that we look at. Obviously, weather is one of them. We need to be able to look at because if they can't prove that intent to defraud, it's not a crime. There's also the easy defenses as far as the specific guidelines that are required under the statute. So again, you have to send a request for a refund, 10 days, hand delivery, give them the copy of the refund, or certified mail with a return receipt. Seems like very simple things for someone to do, but someone who is not looking at the criminal statute may not know that. I may send an email to the contractor and say, I'm requesting a refund. Well, is that considered hand delivered or not? Would be something that we would be able to litigate and argue that by black and white letter law, that's not hand delivery. So there are plenty of, or a phone call, for example, does that constitute as hand delivery? Looking at the statute, maybe not. Those are issues that we can, again, litigate. So there are very specific requirements to charge under this statute. It should just stay civil. A civil court under preponderance of the evidence, a lower standard of proof, they can determine what the monetary value is and make someone pay, or they can make them pay through restitution in the criminal case, which unfortunately is what we see and why we defend people under this statute. Wish it was civil. We wouldn't have to get involved, but obviously there are a lot of defenses and ways that we can defend these cases. And so if someone is charged with the home improvement statute fraud, we want to get involved, and we want to get involved early to start interviewing potential witnesses and gather all of that evidence before text messages are lost, before witnesses move away and we're not able to interview them, things like that. So with the home improvement statute, we discussed how the monetary value is what we look at, and that it's punished the same way that theft is. So we look at, $2,500 to $10,000, $10,000 to $60,000, $60,000 to $250, or $250 and beyond to get all the way to an A felony, and the grades of felonies for each of those, right?
Yeah.
But how do we actually value the dollar amount of the project for punishment purposes? So I have a $100,000 job. I do, $50,000 worth of work. Is that $100,000 theft of $60,000 to $250,000 because the contract was for $100,000, or how does that get punished?
Yeah, so it can be a massive difference, right? It can be the difference between years and years of probation or potential prison time. Yeah. Is you have that $100,000 job and you do $50,000 worth of work. Are we grading as a $60,000 to $250,000, $10,000 to $60,000? Is the alleged victim is always looking at, I want all my money back, right? But when we talked about substantial steps taken, how much work has been done, is really what we're trying to argue is that the total amount should be subtracted from what has already been performed, right? So if I bought that, if we bought that $50,000 worth of lumber, we've laid it, we've put up all the stuff in order to build that dock that we talked about, right? Is really the disputed number here looks more like 50,000 rather than 100,000, and that's obviously the difference between classifications of felonies.
Right, and that's assuming that the person paid the full 100,000, because they're not entitled to money that they didn't pay.
Yes.
The other portion of that too is, how much money is it going to cost to fix the job that was not performed, and is it reasonable? So I quote you $100,000 for the job. I do $50,000 worth. The court's determined it's not a substantial portion, the jury, whatever it might be. And so we're talking about punishment. Then we look at, okay, what was it, $50,000? Well, if I have to hire someone else to do the job and it's going to cost me $75,000 instead of the $50,000, am I entitled to that additional $25,000 in restitution? And can that $25,000 be added to go from, the theft of 10 to 60 to make it a C felony for the $50,000? Adding that $25,000 to go to $60,000 to $250 is a B felony. And maybe not. Again, it depends on, is it reasonable that job is now going to cost $75,000? And if it is, and that's just what the standard quote is, and there's no way to get a lower quote to fix it, then yes, it potentially can be added and enhanced to that B felony from the C. So again, it's very case specific, but again, that is also why we have to get involved early, and getting involved early can potentially mean the difference as far as the punishment if convicted. But then obviously we look at, well, are you going to be convicted in the first place? And that's all the defenses we talked about previously, the investigation we do in order to decrease the likelihood of a conviction and figuring out a way to get this case resolved. And ideally, again, civilly rather than criminally. And there are ways that we can facilitate that and try to make that happen, or potentially get the case dismissed and make them have to go after you civilly because a substantial portion of the job was completed, or one of the other defenses we talked about.